Chicago Justice Project's new podcast covering crime, violence, and justice issues in Chicago. My name is Tracy Siska. I'm your host, and I am also the executive director of the Chicago Justice Project. This podcast is going to bring you deep dives into the data generated by our justice agencies in Chicago, in-depth interviews with experts and researchers, and evaluations of criminal justice policies and practices. We seek to stand above the fray of the daily violence coverage in our city, the anonymous blogs that are exploiting violence for political purposes. We are dedicated to bringing you the context that is sorely missing in all of that. We'll also be challenging head-on the weaponizing of data by our justice agencies in Chicago and Cook County. Unfortunately, crime and violence is not an uncommon event in our city. Neither, though, is the exploitation of these events by our politicians. In today's show, we're bringing you a conversation about the Illinois Freedom of Information Act, or FOIA, the law that allows Illinois residents to get data and records from their public bodies. This law is at the heart of everything the Chicago Justice Project does. Our guest today is Merrick Wayne, a lawyer from Loevy and Loevy, who specializes in FOIA litigation, representing residents of Illinois in the media and nonprofits like us to pry open data and records from our public body, and in our case specifically, the criminal justice agencies. Today's conversation centers on a memo authored by Matt Topic, who runs the FOIA litigation at Loevy, and it was sent to or submitted to the transition committee for incoming Mayor Lori Lightfoot now about a year ago.
If you can give us an idea from your experience, what do you think, where would you rate the Illinois FOIA law, among nationally? Are we some of the worst? Are we some of the best? Are we just in the middle, average, horrible? I mean, it's Illinois, so, where would we rank?
So for Illinois FOIA, I think that we are one of the better states. I'm not going to say we're the best ones. I don't have a full understanding of every single state's FOIA laws as well as I do for Illinois. But a bonus for Illinois is that it is based off of the federal FOIA. So there is guidance beyond what is actually provided in our actual statute. For example, it includes a lot of provisions that you don't see in other states' FOIA laws. We have a robust list of exemptions, and while we do challenge the use of exemptions, it is better to have them explicitly laid out in a statute, because some states, they have a lot more of a leeway to assert exemptions that probably shouldn't apply and wouldn't apply in other states. Additionally, Illinois has hard deadlines on when the public body has to respond by, and these hard deadlines are much lower than at the federal level. So, for example, at the federal level, they would have 20 business days to respond to a FOIA request. In Illinois, the public body has 5 business days with the option to take an additional 5-day extension. And there are many other ways that FOIA in Illinois is a lot better than other states. Another example would be the attorney fees and civil penalties provisions in Illinois FOIA are mandatory when a requester prevails after filing a lawsuit, where other states make it discretionary. So it's harder for some people to bring lawsuits because of the cost that is involved in litigation.
We're going to talk more specifically about a memo that was authored by Matt Topic, who heads up the FOIA litigation at Loevy. And it was a memo he was requested or asked to produce when the Lightfoot administration was transitioning into power last year. And so we're going to talk about pieces of that. You can find it on our website if you want to read the whole thing. But we're only going to deal with a few pieces here that I find interesting and ask Merrick to comment about them. So,
for those who aren't aware, Matt Topic is a colleague of mine. He's the person who founded the FOIA team at Loevy and Loevy. And when Mayor Lightfoot was transitioning into her position as mayor, she began a bunch of different committees where they took people across various types, where they brought in people from various types of industries to discuss platforms and policies that the mayor would carry out. One of those teams had to deal with transparency and public records. So naturally, Matt Topic was a good fit to provide his insight, at least through a memorandum. His memorandum isn't binding at all on the Lightfoot administration, but was rather just a way to recommend what we think would be a better FOIA policy and a more transparent government in Chicago.
One of the things is I want to go over two of the exemptions, which is an exemption limited to its narrowest reasonable interpretation clearly applies to the record, and no plausible legal argument against the exemption claim can be identified. That's one. And the second one is another part of the exemption about why something should be withheld, according to Matt's recommendations, are city residents are certain to suffer a specific, clearly identified, and significant harm from the release of the specific record. So can you comment about those two?
So for the issue of making it the most narrow possible way of the exemption applying, that comes from Illinois FOIA case law, where when we challenge a FOIA denial and it goes to the court through the lawsuit, the court has to interpret the FOIA statute, and case law requires the court to take the FOIA statute at its most narrowed interpretation that favors disclosure. So if the court is unsure of how it should end up ruling on whether an exemption applies, it should err on the side of disclosure, which is by interpreting the FOIA in a narrow way, meaning it narrowly applies to records. So that idea is taking what the court is already doing and implementing it as a citywide policy over FOIA.
Oh, so, well, obviously, as a FOIA advocate, I'd be hugely in favor of that.
Right.
I mean, right, it's a shame, and for those who don't know, Merrick is representing CJP currently in litigation against the Chicago Police Department for FOIA, for failures to follow FOIA. My biggest, or one of our biggest problems is that it seems that we just don't have a proactive FOIA response in the city. The response is, most of the time, is we're going to rely on the burden of suing as being a hurdle too big for someone who wants records to get them.
Yeah, unfortunately, that's a reality of it, is that sometimes we're not sure if a record is being denied because the city would prefer a judge to order it to be released, or if it is some type of administrative, or whether it's some type of administrative error on the city side where they're not complying with FOIA. We don't necessarily know, and we can't look into the minds of them every time. So sometimes we do have to take discovery to find out why the FOIA was violated. And there is a provision in the FOIA that looks for willful and intentional violation. So what Matt meant by harm to the citizens is that when you look at the FOIA statute and you look at what exemptions can be claimed, a lot of them have a higher burden than what the city would lead a requester to normally to believe. For example, when you have the law enforcement exemption under 7.1D, what you see throughout the entire state of Illinois is, and not just in the city of Chicago, but the public bodies use that exemption as a blanket exemption whenever there is any kind of pending law enforcement case, whether it's an administrative case internally through law enforcement agency, or it is a criminal investigation that they're conducting. However, there is no FOIA exemption that says the city can withhold records because there's a criminal investigation. There is a clear, there's a key point in that exemption that it would interfere, and that showing of would is required for any 7.1D exemption, and something that a lot of public bodies fail to do, and is why we end up bringing quite a bit of lawsuits regarding Section 7.1D. So what Matt was trying to say is that when the public bodies in the city of Chicago are asserting an exemption, they're meeting that level that is necessary under the statute. For example, the would, so it would interfere, and that's what he's trying to get at with harming citizens.
Yeah, once again, hugely in favor of that, because I'm really tired and exhausted of getting blanket denials without any details that don't
right.
give, and as a requester, it doesn't give me the ability to judge the legitimacy of that denial, right? So if it's legitimate and they could state, and they're forced to state that why it's legitimate, and then I could understand and interpret it, and sometimes I might agree, you know what, we're just going to have to wait on that. But when it's used so frequently, it's really hard to actually, understand whether it's being used correctly or not.
Yeah, and another type of exemption that would fall under that is with private information. So, for example, social security numbers. We never challenge of redaction made for social security number, we would never expect the public body to release someone's social security number. So in that sense, you would expect the public body, especially in Chicago under this memo, that they would still continue to redact those to prevent any harm that could come to a person by releasing that type of personal information.
Worried about the ramifications of doing their obligation, living up to their obligation and releasing that, and worrying about political blowback. Do you think that's what Matt was talking about?
Well, so Matt was the attorney who got the Laquan McDonald video released in 2015. This is before I was at Loevy and Loevy, but Matt was the one who really led that charge and got the video released. And I think there are definitely some connections to that case in the memo on that issue, like you pointed out. But also just generally speaking, you see this issue come up when you're looking for the emails of a mayor, whether it's in the city of Chicago or a different public body, but getting the actual emails of government officials because they may want to withhold them due to embarrassment. And there is no exemption under FOIA for embarrassment or anything of that like. Same thing with CPD. If there's information in a CPD record or even a state's attorney's record that would help a person who is wrongfully convicted, they can't withhold that information because it would show that our law enforcement got the wrong person in this case.
Okay, my next question, which I find interesting that Matt included it, was this idea around not using, the city will no longer assert the deliberative process exemption under 7.1F under any circumstances. So if I read that to me, then emails and maybe memos that go in discussing a policy change, let's say, for example, they would now be open to FOIA, and they wouldn't be, the public body would no longer be able to say, no, it's part of our deliberative process. Is that what you think they're going after here?
Yeah, that's the idea of what that proposal would be. Commonly, we see with a lot of different public bodies, and not just the city of Chicago, is that they try to use Section 7.1F, which is the deliberative process exemption in Illinois, to withhold records beyond the actual scope of what the exemption should be applied to. And this is one that they really try and get away with and take broad exemptions for. I'm not just saying the city itself, but public bodies throughout the whole state tend to do this. And it's hard from the requester's side to know whether they're legitimate or not, because if you get an email from your public body that you requested from, and you see the to line, you see the from line, you see the subject and the date and time, but then the entire body of the email is redacted, I mean, you really don't have any idea. And we've taken them to court before, different public bodies, and we sued over this exemption. And sometimes the judge will review the records in camera and uphold them. And it's really hard to say from our perspective whether those records should be exempt sometimes because of how broadly the exemption is used and how loosely the public bodies tend to treat the term policy or action. And any kind of discussion of an edit seems to fall under these types of exemptions from what I've seen in my history.
Okay. Another section that I confront a lot, CJP confronts a lot because we're going after large data sets, is this idea of burden. And I've been an advocate over the last 15 or 20 years of virtually getting rid of that exemption and basically getting rid of it for all, but just pretty much all digital data, especially. I don't understand, and one of the things, if I can quote the memo, any burden, which is this section I probably love most of the entire memo, any burden that is the result of inadequate or obsolete record-keeping practices or systems may not be considered as part of the burden analysis. I love that because I have always thought, especially Cook County, the Cook County justice system has kept their data on mainframes, antiquated systems, so that they wouldn't have to worry about turning it over because they could always claim this burden. How do you run into this burden? Is this why this is in? Because you guys run into the burden request or the exemption a lot?
The burden request is something we see frequently. We see it a lot with data, as you're familiar with, Tracy, where they try and treat the amount of rows in Excel as the page numbers, or they try and print out the Excel spreadsheet to say, look at how many pages this is, when the actual burden for reviewing a data set would be looking at the columns and determining whether the column would contain exempt information. And they never try and say, well, if you print this out, this is how many columns there are. It's always based on the rows, which is the incorrect analysis, which is our position on that. As far as burden generally, so for burden, we see it applied a lot by the city, which is why we would like to move past that policy of having the city assert it. It's frankly, it comes up a lot with older records. So if there were records that were maintained in the 90s on paper, the city may claim that they are is more burdensome to then review those because they're stored on paper versus being stored electronically, as a lot of documents are now too. And then generally speaking, in Illinois, I see this exemption come up a lot when it comes to inmates who are doing FOIA requests, particularly when they are trying to get their entire criminal file because they're trying to prove that they're wrongfully convicted. So you'll see public bodies trying to assert undue burden as a way to just withhold the entire criminal file without having to actually go through and redact a social security number here or a date of birth there, but just withhold everything in its entirety instead.
All right, I have one comment, but I want to go after my last question for you. My last one out of the memo. I really like this idea too, which is this law department review, which basically gives, for every new complaint that is filed, the law department has to, within 21 days, explain the city's position and all the factors going on in the case and deliver those to the mayor's office. So they know, and to me, the way I look at this is they not only know, but now they're responsible for carrying on the litigation. They can't claim it, willful. I think the willful blindness issue is like, I didn't know they were doing that. So I really like that. Do you think that'll help?
I think it could help if they implemented that. You see it more as an informal policy, especially with a smaller town or public body, such as like a suburb, where it's more natural for the mayor to be aware of any FOIA lawsuits going on, probably due to the infrequency that a suburb would have to deal with a FOIA lawsuit. This level of the city of Chicago, I frankly don't know how much the mayor is aware of every individual FOIA case that we have going on and that other people have going on, because there are people beyond just Loevy and Loevy who have FOIA lawsuits against the city. So it could be a way to at least bring the mayor's attention to it, where she or any other future mayor could then choose to not litigate a case, try to settle a case because they realize that they do not want to be fighting that in court. Whether it's because they think those records should be released or they have some other ulterior motive, I don't know. But it's better to do that than just having the lawyers of the law department or the FOIA officers kind of decide whether they want to give up on a case or not, and at least put that decision in the hands of the mayor, who would be running it all.
Yeah, I really like that aspect of the memo. I do want the mayors to be involved and know what's going on. I was a little disheartened though. I think it was last week when I received I think I sent it to you all at Loevy, when I received a letter from COPA saying my FOIA was being summarily ended, closed, and then they were going to make me file again whenever all the restrictions on Chicago got lifted. And that was kind of depressing. What would kind of depress me more is it seemed from the mayor's reaction, she didn't know what happened. She didn't know those letters were being sent out. Did you have clients that got those in cases you were involved in?
We did see people discussing how the city was shutting down their FOIA, and I've been continuing to see that, especially at the federal level. The FBI has essentially stopped processing FOIA requests at this point because their FOIA officers are not set up to do remote work, and that's due to the security nature of some of the documents that they have to review in the systems that they're stored in. And I did see that Mayor Lightfoot was not aware of some of these FOIA responses that were going out. And it is a bit crazy out there, considering everything with COVID-19. So we are looking at how public bodies, both at the state level and the federal level, are responding to FOIA requests. And it's a conversation that's happening all across the country with media attorneys and transparency attorneys everywhere, looking at how public bodies are changing their Open Meetings Act laws, or not changing the laws, but how they comply with that, because some public bodies are now shifting to virtual meetings, and how can they do that while following the Open Meetings Act law is a question that they have to meet with. Other public bodies are just claiming a blanket undue burden exemption to comply with FOIA. I do not think that is the policy of the city of Chicago right now, but we're really trying to see how things play out in the world, generally speaking, before we put any significant pressure on anyone to do anything right now.
Right, and I understood, like, when I read it, what bothered me was the fact that it was just denied, and that I would have to start over the process. I being a understanding person and understanding the circumstances, for some of the requests that are not maybe COVID response related, because we need to know what our government's doing right now about the situation that's going on right now. But mine wasn't about that, so I could have seen getting a letter and saying, hey, our FOIA officers are out because of the pandemic, and we're going to pick up, our date to pick up is this date, and that's when we're going to let the time start trolling again. That would have seemed more reasonable than the denial. And I would have loved Lightfoot to come out and announce who decided to send those letters. Whether
it would be very informative. It'd be very informative to the process of how they go about denying requests and how far up the chain FOIA requests go. Because certainly there are some that you don't think that the mayor would need to be looking at before the public body issues a response to it. But then there's others where you do wonder how far up the chain are people aware of the FOIA requests being made.
Yeah, I will say in this round we have a number of FOIAs. The COPA one was about Sergeant Khalil Muhammad, who got suspended only 18 months for unjustified shooting of that black teenager. And in general, the responses, I found them what seems to be, at least at this point, a little more honest than previous denials and previous responses that I got. But I did get a few where they said, well, we have to check with other bodies, other public bodies. And that kind of caught my attention, because it's like, no, what other public body? You're the public body. I have to sue the police department, or I have to sue the police board. You're an individual entity related to FOIA. You shouldn't have to check with anyone. But they put it down on paper, so I just thought it was interesting. Maybe it's a little more transparency in their FOIA work. Only time will tell. I would have preferred, and I'm going to make more publicity about this, I would have preferred if Lightfoot came in. I think we need to switch the burden from the requesters to the agencies. And I think what the city needs to do is go agency by agency and have them prepare a list of all the data sets, what can automatically be made public, which ones you can redact partially and make public, and what have to be withheld. And then they should just be posting regular updates. There should not be this problem where we have to keep going back and forth with new requests to get updates. I think a lot of this, I don't mean to put you out of work there, Merrick, but a lot of this could just be settled if it was just upfront the policy of the city to be transparent in everything they do. And then there may be legitimate, for individual items or individual data sets, there may be legitimate discussions to have about whether or not something should be legitimately withheld. And we might disagree with the city, and it might have to go to court over one individual data set from one agency or another. But where we are now, where we pretty much have to FOIA and send a request in for everything we want and pray they respond, and then if they don't, it takes the wheels of justice grind slowly. With Loevy's representation of us, they've ground well, but it isn't fast. It's not your fault. That is how the system is. So it's just, if you're trying to do research on something now and publish it now, and they want to withhold it, it's a year and a half before the lawsuit may bear fruit. And that's, I'm just complaining. It's just a burden that we shouldn't have to lead. So,
well, first off, I'd point out that under the FOIA, the burden is on the public body to prove any of their exemptions. So while it may feel like to anyone out there who's submitting a FOIA request and getting denied that the burden is on them to show why they deserve these records, there is a public policy that all persons, not just citizens, but all persons are entitled to full and complete access of the records pertaining to the public bodies and the actions of our government officials. And then it is the public body's burden to prove by clear and convincing evidence that any exemptions that the public body asserts actually applies to the records. So that is something you should always keep in mind if you're ever filing FOIA requests, that it's up to the public body to prove why you should not have access to it. And I know you made a joke about putting us out of business, but frankly, I mean, that is our main goal, is that in an ideal world, I wouldn't have this job of being able to sue people over FOIA requests because the FOIA requests are being complied with. And that's what really a lot of the enforcement provisions in the FOIA are trying to get at, is that they're set up in a way that incentivizes the public bodies to comply with the law.
Right, and I think in a perfect world, after Loevy is successful with a litigation and settling the record about what should and should not be public around certain data, then the public body should just start posting it, and we shouldn't have to go back and re-FOIA it, and then the mayor should make sure of that. We need to make it a political consequence to not doing that, because they have more money than us. Right? Okay. So thank you very much, Merrick. I really appreciate it. Everyone else, the memo is going to be up on our website with the podcast and the notes, and I really appreciate your time. Thanks, and hopefully your family stays healthy and safe, and we can do this in person sometime in the summer.
Yeah, thank you for having me on, Tracy. It was really great talking with you. I'm glad we were able to discuss FOIA with your listeners so that they can submit their own FOIA requests in the future as well. I hope you're staying healthy and your family's doing well too.
Thank you, sir.
I want to thank Merrick Wayne for joining us today and this great conversation about FOIA. I wish I could say that I've seen a seismic shift in how the city responds to FOIA and FOIA litigation since Mayor Lightfoot came in. However, the Chicago Police Department continues to fight our litigation, just like they did under Rahm Emanuel. Lies, deceit, and cover-up, everything they can do to make sure that they're not releasing data. Real change is not going to come to FOIA and transparency in the city until we don't have to file FOIA requests anymore. There needs to be a shift to where public bodies are just required to post their data. And then if there's arguments over what should be kept for secrecy and privacy and what shouldn't be, we can have those arguments. But as long as we're in a place where people still have to be submitting requests for data, we're not going to ever get to where we want to be. That is a status quo that is just going to be hurting residents, researchers, and helping all the public bodies, specifically in our case, justice agencies. One last thing is every segment we're going to end our podcast either commending a piece of local journalism or trashing a piece of wretched local journalism. Today's segment is brought to you by Jermont Terry and CBS 2 Chicago, where he does a report about how there's been a massive crime drop in the city post the shelter in place, and the fact that activists fear the drop in crime won't last. Well, 2 million or so people are sheltering in their homes. Another maybe 5, 6, 7, 800,000 million coming into the city every day for work aren't there. You're talking about tens of millions of interactions between people that have just stopped, disappeared. Yeah, crime is going to drop. That's not news. I know we have this fetish from the local media that we got to continue to report on crime and violence, but you'd think with coronavirus there'd be enough things to exploit to get the clicks that you wouldn't have to do this type of story. And yeah, when those interactions get restored and we're past this time, crime is going to go back up. That's a natural of having 3 million plus human beings interact in a city so close together. There's going to be crime and violence. That's just the way it is. You can find more information about the Chicago Justice Project on our website at chicagojustice.org. You can subscribe to our YouTube channel, follow us on Facebook and Twitter, and support our work through our Patreon campaign.